Welcome, everyone, to the University of New Mexico Law and Mental Health Didactic Series, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences, along with the New Mexico Behavioral Health Services Division. We're so glad to have so many of you joining us here today. I'm Anthony Perillo, the Forensic Psychology Training Director here in the Division of Forensic Behavioral Sciences in the University of New Mexico's Department of Psychiatry and Behavioral Sciences. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box, not the chat box, but the Q&A box, anytime that you feel comfortable. Just know that we do hold questions until the end. We try to get to as many as we can as possible, but just forgive us if we don't get to yours. If you're pursuing continuing medical education credits, there will be a sign-in sheet in the chat box shortly. For those that are pursuing APA continuing education credits, a link for the survey that you'll complete will also be posted in the chat box sometime later during the presentation. Make sure you open that link and save your certificate after you complete the survey, because we don't have access to the completed surveys or keep copies of your certificate after the fact. As a heads up, a recording and PowerPoint slides for this talk will be available to you sometime later this week. And for next week's talk in the series, we'll have Dr. Brianna Beaupre, who will be discussing gender-responsive correctional strategies. But let's get back to this week. I'd like to introduce you to today's speaker, who will be discussing the Sexual Violent Predator Act and penile plethysmograph evaluations, with sexual behavior evaluations in particular. This is Dr. Emily Gottfried. Dr. Emily Gottfried is an associate professor of psychiatry and behavioral sciences at MUSC, the Medical University of South Carolina. As director of MUSC's Sexual Behaviors Clinic and Lab, she conducts sexual violence risk assessments referred by the courts, attorneys, and pursuant to South Carolina's Sexually Violent Predator Act. She regularly provides expert testimony on sexual behavior and penile plethysmography. I don't know why I'm messing that one up today. Dr. Gottfried is a licensed psychologist in South Carolina and Georgia, and additionally conducts treatment and risk evaluations and provides sexual behavior treatment. She conducts research on sexual arousal, non-consensual and abusive sexual behaviors, and assessment methods. She's currently the research representative for the Association of the Prevention and Treatment of Sexual Abuse, ATSA, the secretary of the South Carolina chapter of ATSA, SCATSA, and the president-elect of the assessment section of Division 12, Clinical Psychology, of the American Psychological Association, having recently also been the Professional Development of Women Committee Chair for APLS, Division 41 of the American Psychology Association. Dr. Gottfried, Emily, on behalf of the University of New Mexico, can I say how excited we are to have you joining our series, and thankful for you sharing your expertise and contributing to this really needed, discussed topic. I will go ahead and throw it over to you.
Perfect. Thank you, Anthony. Thank you for having me. So good morning, good afternoon to everyone. Let's see. Okay, so I think there was some information about the CEs, so let me skip over that. Disclosure, so I have no financial disclosures, nothing to disclose. So let's get into the presentation. Let me move this a little bit. Okay, so today we're going to talk about sexually violent predator acts in the United States. Also talk about other countries and jurisdictions that have not sexually violent predator acts, but other laws and regulations. We're going to discuss some of the relevant case law. We will talk about penile plethysmography, including the appropriate and inappropriate use of that test in sexual behavior evaluations. Talk a little bit about initiatives to try to standardize PPG further, and talk about using the PPG in court. So let's get right into it. So to start, we're going to talk about sexually violent predator laws in the United States. And so these are referred to as SVP, sexually violent predator, sometimes SDP, sexually dangerous person acts. And they allow for the indefinite civil commitment of individuals who have been convicted of sexual offenses after the completion of their sentence. These are really legislative reactions to high-profile sexual offense cases, often against children, and the risks that these individuals may pose for future sexual offenses. So the first SVP or SDP Act that we had in modern day was in 1990 in the state of Washington. So they enacted the first sexually violent predator law in response to two offenses that occurred in Washington in 1989. So in 1989 in Tacoma, Washington, Earl Schreiner abducted and sexually offended against a 7-year-old boy. Very gruesome case, but ultimately the victim survived, and he identified Mr. Schreiner, who had previous serious offenses, including homicide, kidnapping, and the assault of teenage girls. And then a few months after that, also in Washington State, there were two young brothers who were found sodomized and murdered in Vancouver, Washington. Mr. Dodd was a 28-year-old man who had a long history of prior sexual offenses. He was arrested for a separate sexual offense against a young boy, and he confessed to these murders of the young brothers. So those were the two things that kind of preceded Washington enacting their first sexually violent, or the first sexually violent predator act. And so the general criteria for these sexually violent predator acts, kind of the wording depends on the state, but in general, the person has to have been convicted or charged with a sexually violent offense, and that is typically defined by that state's statute. And it could just be charged because in certain states, if somebody has been charged and then found to be permanently incompetent to stand trial or not guilty by reason of insanity, they still can be civilly committed under an SVP Act. But typically it's somebody who has been convicted of a sexually violent offense and they have a mental abnormality or a personality disorder, is the wording that we use here in South Carolina, that results in impairment, like volitional impairment. And that mental abnormality or personality disorder predisposes them to commit future acts of sexual violence. And so the data are pretty hard to find, but it was estimated that individuals who were civilly committed under Sexually Violent Predator Act in the United States was over 6,300 people who had been committed. So in the United States, there are 20 states and Washington, D.C., and then the United States federal government that have a version of Sexually Violent Predator Law or Dangerous Person Act. So I've spent some time kind of looking at this list, trying to look at patterns, but I don't really necessarily see any like rhyme or reason for why some states have this act and others don't. Maybe you know the answer and you can put it in the Q&A box, because this is something that I've been curious about. So I practice in South Carolina. I'm also licensed in Georgia, and I went to school in Florida. So we have the act in South Carolina, and they have it in Florida, but it's not in Georgia. It's not to the north of us in North Carolina. So, you know, looking at these states, different political climates, yeah, no real pattern that I've identified of why certain states have it and certain states don't. So kind of diving into the relevant case law. So first was Allen v. Illinois, and this was a 1986 case that was heard by the US Supreme Court. And that court held that the Illinois Sexually Dangerous Person Act was civil and not criminal. And therefore, the Fifth Amendment right that we have against self-incrimination for criminal cases did not apply to the SDP Act in Illinois. That court also noted that the aim of the act was for treatment and it was not meant to be punishment. Then what we would call the landmark of the landmark cases for SVP is Kansas v. Hendricks, 1997, also a Supreme Court case. That court held that Kansas's definition of mental abnormality, which will be discussed on the next slide, satisfied due process rights. So that court affirmed that the act was not meant to be punishment and did not violate protections against double jeopardy or being tried twice for the same case, or ex post facto, which means that a law applies to someone who committed the crime before the law was enacted. So when Mr. Hendricks had committed his crime, there was no Sexually Violent Predator Act, but the court held that that was not relevant to this case, or it didn't matter, and he still fell under the purview of being committed under this act. Okay. Then in 2002, the Supreme Court held that there was only some lack of control required in the Kansas sexually violent predator law. So you didn't need to have a total or complete lack of control. It was only some lack of control. And then in 2010, the Supreme Court held that Congress has the authority to civilly commit prisoners, and it upheld the federal sexually violent predator law, which is the Adam Walsh Child and Public Safety Law, I believe is the last part of it. So they upheld that as being constitutional. So the Supreme Court has consistently over the years affirmed that SVP laws are civil, not criminal, so it doesn't equate to double jeopardy, and that their purpose is not to punish somebody, rather to provide treatment for them. So in South Carolina, the wording in our statute is that the person must have a mental abnormality or personality disorder, and all of the sexually violent predator acts in the United States require some version of these words. So some mental illness, mental disorder, mental abnormality that predisposes them to commit acts of future sexual violence. But what is a mental abnormality? So definitions largely depend on the particular state. So for example, 11 states use the Kansas definition from Kansas v. Hendricks, which they found to be a congenital or acquired condition affecting the emotional or volitional capacity, which predisposes the person to commit sexually violent offenses in a degree constituting such person a menace to the health and safety of others. Other states, including South Carolina, where I live, use this next one, a mental condition affecting a person's emotional or volitional capacity, which predisposes the person to commit sexually violent offenses. And the federal government uses a person suffers from a serious mental illness, abnormality, or disorder, as a result of which he would have serious difficulty in refraining from sexually violent conduct or child molestation if released. And so usually personality disorders kind of fall under a mental abnormality. And so in South Carolina, they specify mental abnormality and or personality disorder, but most of the 20 states, Washington, D.C., federal government allow that the diagnosis be a personality disorder. Okay, and so part of the act is that the mental abnormality or personality disorder makes them likely to commit another sexually violent offense. But how likely is likely? What does likely mean? So likely to engage in sexually violent behavior in the future, does that mean a greater than 50% chance? Does it mean more likely than not, more probably than not, a substantial probability? A person's likely is that their risk of sexual recidivism poses a menace to the health and safety of others. So these are from different state statutes, and the feds, so the US federal government and 8 states do not define likely in their statutes. So this is up to the trier of fact interpretation of what likely actually means. So who gets recommended for civil commitment under our Sexually Violent Predator Act? So there is really limited information about who gets recommended for commitments. And there was this study out of Florida that looked at characteristics of 450 men who were evaluated for civil commitment under the Florida Sexually Violent Predator Act. kind of just briefly, I put the results up here, but just kind of to direct your attention. So the Static 99, the Minnesota Sex Offender Screening Tool revised, and the Psychopathy Checklist revised were the strongest predictors of being recommended by the evaluator for commitments. Victim age was negatively correlated. So younger victims, when someone had younger victims, they were more likely to be recommended for civil commitments. Having to satisfy or have probation, condition of probation after release was also negatively correlated with recommendations for civil commitment. So people who had to serve time on probation after release were less likely to be recommended for civil commitment. But you probably imagine there are some issues and criticisms surrounding the SVP laws in the United States. So they've been called things that are hastily constructed. So these are legislative reactions to usually a horrible crime being committed, showing like something is being done, like we're doing something, this is what we're going to do. But they've been criticized as being really hastily constructed. They also note that these statutes include really poorly defined psycholegal constructs. So we kind of talked about this on the other slides, but what is a mental abnormality? Like how likely is likely, and what does volitional control actually mean, and how do you necessarily assess that? There's also been noted that there's a meager understanding of factors that cause individuals to engage in sexual offenses, such that many lay people assume the rate of sexual recidivism is extremely high, when we know from the literature that detected sexual recidivism is only around 13 to 15%. Also, it's been noted that there's an assumption of dangerousness as being an attribute of the individual, rather than the result of this complex interaction between the person and their environment. And then as the courts have granted cert and examined over the years, potentially constitutional issues. So although the United States, only the United States has enacted sexually violent predator laws, other countries have enacted laws to manage individuals who have committed sexual offenses and who pose a high risk of sexual reoffenses in the community following release from incarceration. So in Australia, they have the Dangerous Prisoners Act, which has indefinite detention in prison if there is an unacceptable risk that the person will commit a serious sexual offense if released. Interestingly, this is not based on a diagnosis. So this is looking at their risk, but not factoring in whether or not they have a mental disorder, including a paraphilic disorder or a personality disorder that makes them likely to reoffend. In the UK, they have the offender personality disorder pathway. And these individuals are detained and treated in high security hospitals and prison settings. And these are for individuals who have been determined to be more likely than not to commit an offense within 5 years that might be expected to lead to serious physical or psychological harm from which the victim would find it difficult or impossible to recover. They have a significant personality disorder, and they present a threat that is functionally linked to that significant personality disorder. And then in Germany, this is part of their criminal code, and they receive a fixed sentence based on the guilty verdict. And then there's preventative confinement based on the risk of recidivism in the name of public safety. And then in Canada, they enacted an SVP type legislation in response to a high profile crime involving someone who committed a sexual offense. And this was enacted like nearly a decade after an 11-year-old male child was abducted, raped, and murdered in Ontario. And so this built upon Canada's dangerous offender law, and it added 10 additional years of supervision for certain dangerous offenders. These were individuals who had been convicted of a serious personal offense that carried a sentence of at least 10 years in prison, and those who were found to present a continuing threat to the life, safety, or physical or mental well-being of other persons. And so individuals under this act, they receive indeterminate prison sentences, but their cases are reviewed 7 years after the offense and then every 2 years thereafter to determine whether they should be released on parole. All right, so that is my overview of sexually violent predator acts in the United States and beyond. So I want to switch gears a little bit and talk about penile plethysmography. And to me, these two topics go together because we use penile plethysmography or PPG in sexual behavior evaluations. And they are a data point that can potentially be useful in assessing someone's risk of sexually reoffending. So just briefly, penile plethysmography is a physiological measure of male sexual arousal. It is an objective measurement of changes to the circumference of the penis in response to both sexual and non-sexual stimuli. It has been called the gold standard of male sexual arousal. And in 2002, Elizabeth Letourneau noted that it has remained the single best measure of, quote, deviant sexual arousal. So how it works is you are looking at changes to the circumference of the penis to assess sexual arousal. So the idea is that men who sexually offended against children and are sexually aroused by prepubescent children are expected to show greater or equal arousal to the child scenarios than those featuring consenting adults. So why is it important to objectively assess sexual arousal? We know from sexual behavior evaluations that individuals undergoing these evaluations have a well-founded and understandable motivation to not be totally forthcoming about what they're aroused by. I think people have a natural tendency to want to have self-preservation and not talk about things that could potentially be harmful to them or get them in trouble. So if they are potentially facing up to an indefinite civil commitment, they might not be totally forthcoming about what they are sexually aroused by. And it is important to assess arousal because arousal can be a risk factor for sexual recidivism. So looking at these really large meta-analyses that were published over the years, the Mann et al. Meta-analysis in 2010 noted that sexual preference for children assessed via PPG was a strong risk factor or predictor of sexual recidivism. That was also discussed in both of Hansen's meta-analyses in 1998 and 2005. And so when you include PPG in a sexual behavior evaluation, it's very important to note that this is just one single data point and just one part of what should be a comprehensive sexual behavior evaluation in which you're assessing general psychiatric symptoms, doing an assessment of their sexual behavior history. You might be looking at neuropsychological measures, other physiological measures, doing risk-specific measures, doing a solid clinical interview with them, conducting collateral interviews, reviewing records. So this is just one piece of that comprehensive evaluation. So the last updated practice guidelines for the assessment, treatment, and management of male adult sexual abusers was published by ATSA in 2014, where they discuss the ethical use of including penile plethysmography data when you're formulating treatment plans or doing assessments with men who have been charged with or convicted of sexual offenses. They noted that PPG data can be used as objective data on male sexual arousal, and you can use it for, helping diagnose paraphilic disorders. You can use it to assess other atypical sexual interests. You can use it to increase the client, if you're in treatment, or the examinee's disclosure. And it's a really great way to measure changes in arousal over the course of treatment. So if you're treating someone and you are teaching them strategies to manage that paraphilic arousal, what better way to test if that treatment is working than bring them into the lab and see in real time. They also note that PPG data should never be used as the sole criterion to assess paraphilic or atypical sexual interests. Just because somebody is showing arousal to, say, child stimuli on the PPG doesn't mean, anything necessarily. So you're never going to use PPG results as the only data point. So you're not going to use them as the sole criterion in estimating their risk for engaging in abusive behavior. So if somebody has that arousal, that doesn't mean that they have acted on it, that they would ever act on it. It's just showing you what they were aroused by today in the lab. You never want to use it as the sole criterion for making recommendations about release to the community or civil commitments. And I've already mentioned this, but the last one, it's not a polygraph. We don't use polygraphs in that way, but you're not going to use it to draw any conclusion that they committed a specific crime or a specific act, or that they will in the future. So during a PPG examination, the examinee is presented with a variety of stimuli that might include prepubescent children, adolescents, adults, male and female, and the content can range from persuasive, coercive, sexually violent, non-sexually violent, and you're comparing their arousal to consenting adults and neutral, non-sexual stimuli. So in the United States, we have no medical exemption to our federal child pornography laws. So when we present examinees with child stimuli for the PPG, they're all audio. So they are hearing verbal depictions of sexual contact with children, but they are not seeing anything that would constitute child pornography. But as we'll talk about, other countries do have that exemption. So with everything and with a test like this, there have been issues raised. So one is that there is a lack of standardization to administer PPGs across sites. And so one of the major reasons for that is that there are these differences in the laws that we have between countries. So there's a lab that I do a lot of work with in Canada, and they are able to use something that would be considered child pornography in the United States because Canada has a medical exemption. And so when you have a lab who has been doing PPGs for 30 years and their stimuli work really well, it's hard to get labs to change things because your lab can't do things a certain way because of the laws. So that's one of the major standardization issues. And I'm going to talk about our international standardization work group on the next slide. And then another major criticism of the PPG is that some offenders do not show, quote, expected arousal patterns. But to me, this one makes a lot of sense because we know that there are a lot of etiologies or a lot of reasons for why people commit sexual offenses. So having pedophilic disorder or having pedophilic arousal is one reason why somebody might sexually offend against a child, but not everybody who sexually offends against children have pedophilic disorder. And so you wouldn't expect that somebody who is not sexually aroused by children to show that arousal in the lab. But that is also a criticism. And so trying to work on the standardization issue, in 2017, an international standardization work group was developed. This was spearheaded by Lisa Murphy and the late dear Paul Fedoroff. They worked at the Royal in Ottawa, in Canada, and they wanted to develop methods for multi-site standardization. And the first international consensus meeting was in 2017. And in that meeting, they had representatives from Canada, Czech Republic, Russia, the United Kingdom, and the United States, where they were comparing different types of assessment methods. So the assessment protocols, the way that you analyze the PPG results, interpretation of the results, the different stimuli used. And they also explored how different sites use PPG in treatment. So types of patients that were treated, different interventions, barriers to using this, and future directions. So hopefully this group can continue the standardization process, because that is one of the major criticisms of the PPG, is that the specificity and sensitivity might vary across sites, and that different sites do different things. So next, I want to talk about using penile plethysmography data in court. And this is based on a 2020 paper that we wrote for behavioral sciences and the law. So what are the potential uses for using penile plethysmography data in court? So I guess one use could be using the results to determine if somebody is guilty or innocent during a trial, using the results in sentencing, and using them for legal designations guided by risk to the public. So let's take the first one. So do we use the results to determine innocent or guilt during a trial? No. So the PPG cannot act as a determination of guilt or innocence for a person accused. Just because somebody is showing quote unquote deviant response profiles is not an indication that they're guilty of committing a past offense. So the PPG is not a lie detector, and it should never be used when determining culpability of a particular offense. And so it's not used for this. It's not used for this in the US, in Canada, or the UK. And I just mentioned those countries because that is what we were comparing in this article in 2020. So we were reviewing practices and comparing Canada to the UK to the United States. Okay. All right, so post-conviction, so using been convicted might help the trier of fact. So either the judge or the jury have insight into the person's diagnoses, their individualized risk of recidivism, their potential for rehabilitation. So looking at treatment suitability, and also developing specific treatment targets. And it is widely used in courts in Canada, the UK, and the Czech Republic for those purposes. But what about here in the United States? So to date, the US Supreme Court has not granted cert or issued any opinion or ruled on anything related to the PPG. There are some appeals court cases that did. A particularly notable negative case would be Weber v. the US. And in this behavioral sciences and the law article that we published, there's a section where we kind of go through the different briefs of different appeals court cases on the PPG, where it really suggested that the justices were really ill-informed. So some of the misperceptions were that an examinee has to masturbate before they can take the test. That's not true. If somebody touches themselves or is masturbating during the test, that invalidates the test. So if somebody were to have an orgasm during the test, you would have to wait for the refractory period to end. I'm trying to think what else was in there. I think I put my own kind of story in that article. There was an attorney that we had here locally in South Carolina who argued that the test should not be allowed into evidence because it was developed in a communist country and therefore it was a communist test. But when you read the holdings and the briefs from the appeals court, there are a lot of arguments related to those kinds of things. So what about in the US? It really varies by the jurisdiction. Here in South Carolina, where I practice most frequently, the PPG gets in, I'd say a little bit more than half of the time, depending on the judge. And then sometimes it gets appealed. And our South Carolina Supreme Court actually recently granted cert to hear a case about penile plethysmography. So we'll see how that goes, what way that goes. But let's talk about PPG and Daubert in the United States. So as you know, in US federal law, the Daubert standard is a rule of evidence regarding the admissibility of expert witness testimony and evidence. And so each state might use their own either version of Daubert or a variation of it, or their own case law of what is evidence, but generally they're related to at least some of the Daubert factors. So for Daubert, in order for something to be admitted into evidence, you have to be able to show whether or not the theory or technique has been tested or can be tested, whether it's been subjected to peer review and publication, its known or potential error rate, the existence and maintenance of standards controlling its operation, and whether it has attracted widespread acceptance within a relevant scientific community. Okay, so I want to go through each of the Daubert criteria for PPG. And so the first two are whether it can and has been tested and whether it's been subjected to peer review and publication. So penile plethysmography has been used and published on since the 1950s. So there are tons of studies conducted, peer-reviewed, and published regarding the use of penile plethysmography. And this isn't just in the sexual offense literature. This is in the literature for urology and erectile dysfunction. And I made the mistake once in court of saying that there were at least 100 articles on the PPG, and then was ordered to produce 100 articles the following day. So I had to run home and go through my EndNote and luckily easily find 100 articles on the PPG, but that kind of taught me a lesson to not throw out a random number that I just kind of made up on the spot. But all of that to say that the PPG satisfies that because there are a large number of studies that have been conducted, peer-reviewed, and published on penile plethysmography. So for its known error rate, so we know that for a test, you have to balance specificity with sensitivity. And so the PPG across studies has been shown to have high specificity. And so this depends on where you cut your score, right? So what is more important or what is more dangerous? So for penile plethysmography, especially because this is just only one lone single data point that we use, it's more important for a test to have a high specificity, and sometimes then you have to sacrifice the sensitivity. So for specificity, that's a true negative. So that is somebody who, for example, is not aroused by prepubescent children, and the results of penile plethysmography show that they did not demonstrate clinically significant arousal to prepubescent children. Sensitivity is the true positive rate, and so that is somebody who, for example, has sexual arousal to prepubescent children, and the PPG shows that they have that arousal. And so for a test like the PPG, because it's only one data point, I think that it's better to miss somebody that has that arousal than falsely say somebody has pedophilic arousal when they actually don't. But we know that it's really difficult to show arousal to something that you're not aroused by. It is much easier to dissimulate or not show arousal to something that you are aroused by. And the PPG, like a lot of tests, is susceptible to dissimulation. So people can do things to try and manipulate the results of the test. We use countermeasures to try to help with some of this. So somebody might be holding their breath when they start feeling aroused, and that might help them not show arousal. They might squirm in their chair, start moving around a lot, and we ask them to remain still during the 2.5-minute trials of the PPG. So with the countermeasures, because they're sitting on a pad, we can record their movement and see if the person is starting to show arousal, and then there's a lot of movement, and then the arousal is gone. So we can look at that for potential dissimulation. We can see if somebody is flexing, so potentially trying to become aroused or show arousal to something like consenting adults that they want to show arousal to. But then there are also other ways that we can't see on the countermeasures. So somebody could do cognitive suppression, where they think about baseball or try to distract themselves. Measures that we have to try to combat that is every so often on the trials, the PPG technician will ask the examinee to briefly describe the scenario they just heard. So trying to make sure that they're paying attention. But all of that to say that the PPG is susceptible to dissimulation. And so that's why we have this range of sensitivity. Also in this vein is the 2019 McPhail and colleagues meta-analysis. And this is one of my favorite studies. He included 53 studies that had almost 9,500 participants, including 4,700 men who had committed sexual offenses against children, 2,085 men who had committed sexual offenses against adults, 541 people who had gone on to have a detected reoffense, and almost 2,200 who had no detected reoffenses. There were people in these studies that did not commit any sexual offenses. And then they compared the age stimuli on the PPGs that they had been administered for those studies. So they grouped them into a pedophilic category, that was stimuli describing or featuring children under the age of 13. Epiphilic, those were pubescent, so 13 to 15. He also had a category called combined, and that was for the studies where in the methods section, they said they used child stimuli in the PPG, but didn't specify the age. And then they also looked at adult stimuli. So some key findings from this meta-analysis was that when PPGs had slide only, so just images, and audio plus slide, this accurately predicted recidivism. And the PPG results differentiated men who offended against children from all other comparison groups in terms of the pedophilic stimuli. They also reported that when using standardized scores, so that would be Z-scores rather than raw scores on the PPG, that produced larger discrimination between the groups. And the predictive effect sizes were just as strong or stronger than most known risk factors for recidivism. And that the PPG predicted recidivism in extrafamilial victims for both male and female victims. And if anybody wants copies of any of the articles that I discussed, I have a reference section on my slides, but you can also email me and I'd be glad to send you any of these articles as well. Okay, so moving on to the next Daubert criterion, that is the existence and maintenance of standards controlling its operation. So PPG technicians and clinical analysts who are certified to interpret results of the PPG, they should be certified. There is a certification process through one of the companies that sells PPG hardware and software, but I think there are multiple ways that you could get certified on PPG. And so all PPGs should be interpreted or administered and interpreted in the exact same way. So you want to make sure that the gauge that you're using is properly calibrated, that you're using countermeasures. So you're measuring respiration, movements, that everybody who works in your lab is certified, that everything is done in the same way. We control the temperature and the humidity in our lab. And we do it all the same way because we have a checklist, and I think that really adds to maintaining the standards of controlling the operation. And then the last Daubert factor is whether the method has attracted widespread acceptance within a relevant scientific community. So the PPG has been approved by, or certain PPG software, hardware has been approved by the United States Food and Drug Administration. It's also mentioned in the DSM-5. It's discussed in the ATSA practice guidelines for assessing and treating adult men. And in the DSM-5 text revision, they noted, this is in the section for paraphilic disorders under pedophilic disorder, they note that psychophysiological measures of sexual interest may sometimes be useful when an individual's history suggests the possible presence of pedophilic disorder, but the individual denies strong or preferential attraction to children. The most thoroughly researched and longest used of such measures is penile plethysmography, although the sensitivity and specificity of diagnosis may vary across sites which frequently use different stimuli, procedures, and scoring. And this is a text revision from the 2013 version of the DSM-5, where they didn't note these last couple words. So I believe it was just the sensitivity and specificity may vary across sites. And then text revision, they added why it might differ. So I think the end message about PPG in court and Daubert in the United States is kind of to stay tuned. So I think that there are certain states and certain jurisdictions where it's looked upon more favorably. I think in Washington state, it can be the court order, it can be part of the evaluation. Whereas in my state where I practice, it really varies on, I'd say, the judge in the case and the attorneys. Yes. So that's my presentation for today. I'd be glad to answer any questions. My email is on there if you want to email me any additional questions or any resources, but kind of my meta message is I think that taken together, responsible use of penile plethysmography can be a really important component of comprehensive evaluations of sexual behavior, but should never be used as the sole data point for anything. References up. Yeah, are there, and there's the link.
Well, thank you so much, Emily, Dr. Gottfried, for that thorough presentation and bringing it back to what this is all about in terms of it being a valuable data point in understanding sexual behavior broadly, rather than a be-all end-all reliance on assessment. We do have a number of questions from the audience already. Of course, feel free to enter more in the Q&A box if you have any. I will do my best to get through a couple of these, and Emily has volunteered a little bit of extra time here to respond to those questions. Kind of going off of that end statement that you have here about the usefulness of the PPG. Somebody asks how you do integrate PPG results in a broader actuarial risk assessment for sexual recidivism. They ask how much weight is placed on it relative to actuarial data, and how you manage risk of bias when considering different sources of information in your SVP work, like PPG results versus actuarial risk scores.
Yeah, I think that's a really great question. I think that could be its own full day workshop. And I've been asked on the stand how much weight I put on each thing, and that's really hard for me to quantify. So I'm looking at the research base. I'm looking at what we know about actuarials. I'm looking at the diagnosis. I'm looking at protective factors. I'm looking at things that can mitigate risk. So I don't know that you can put a number on how much this data points, is worth compared to another one. I think different sources of data weigh differently. So I guess all I would say for that is that would never be something that would completely change my opinion, but it would be one data point, and it's usually looking at diagnoses. So if somebody has multiple offenses against prepubescent children, the person is saying, I'm not aroused by children, and that data point is important for the diagnosis, then that would be, I'd say, more important than in another case where somebody has like a flatline PPG, or in another situation where an examinee says, yes, I'm sexually aroused by prepubescent children, I masturbate to fantasies of them, it's something I'm working on in treatment, then PPG results are probably not really necessary because you kind of have those data. So it's not a very satisfying answer to that question. And I think, like a lot of things, it depends, and it should never be 50% weight or 100% of the weight you're giving all data points. Yeah, I think that's the best I can do for that question.
Absolutely. There can't be a finite answer for that by any means. A couple of people, as you talked about the PPG, used the word that it sounds invasive, potentially. And so a couple of people asked about if a potential evaluee refuses to participate, and one, how you handle that. Do they have the right to refuse? How that refusal might impact your risk assessment in any way. If you could just talk about that potential right to refusal.
Sure. Let me pull up the chat box too. Yes. So people, when I do evaluations, even when they're court ordered, any kind of evaluation I do, I tell the person, like, even if a judge ordered this, I'm not going to hold you down and do this test or this interview on you, right? So people have a right to refuse, but then it's up to the court to decide how they want to proceed. So I'm never going to do anything against someone's will, but when a judge is ordering me to do something, I need to figure out how am I going to be compliant with this court order signed by a judge, and also respect a person's autonomy and refusal to participate. So we don't do any test or any interview on somebody who refuses. What else was in there? There was invasive, I think, was one of them. So it can be invasive. The person is sitting in a private room by themselves. They're putting the penile gauge on themselves. The technician is not in there. They are not exposed during the test, but certainly putting something on your penis and then covering yourself up and sitting in a room by yourself still could be invasive. Yeah, sorry, Anthony. I feel like there was a couple questions in there, and now I'm forgetting.
I think you did cover all the prongs of the ones that at least I threw your way there from one of our audience members. A couple of people asked about particularly using the PPG in assessing people that have committed rape. One question was, how accurate are PPGs with men who have raped adult women and are diagnosed with sadism?
Yeah, that's a great question. So the literature is a little bit mixed on that. There is something, it seems, about arousal to sadistic sexual acts that is difficult to capture in the lab. So individuals in research studies or in evaluations who report sadistic arousal might not show that arousal in the lab. So the PPG is the most most of the research is supportive of it looking at pedophilic sexual interests. So if you have somebody who has committed rapes and you're questioning whether or not they have paraphilic coercive disorder or sexual sadism disorder, not showing that arousal on the PPG doesn't necessarily mean that they don't have it. It's just a construct that seems difficult to recreate in the lab setting of what somebody with those disorders finds arousing.
What are the advantages of the PPG over other methods of assessing sexual interest, such as viewing time?
Yeah, that's a really good question because there have been some studies looking at this and the results are kind of mixed. So there are some studies showing that viewing time measures are just as good and less invasive than penile plethysmography, and others showing that the PPG is superior in assessing that. I think it's difficult with some of the viewing time measures because I think when you really think about it and get into it, that's looking at interest, sexual interest, where PPG is purported to be looking at arousal, and are arousal and interest the same thing? And at least the VRT or the visual reaction time measures that I use, not a lot of research has been done on them by people who didn't make that particular instrument. So it's hard to have an independent test of that. Yeah, so sometimes I use both and the results don't always perfectly line up, but there is a literature base, if you're interested in that, of studies that compared viewing time with PPG and the MSI and some other, there definitely are some studies comparing those.
Thank you. Somebody was curious about your thoughts of implementing the PPG as well as polygraph testing. They put as an aside in sex offense treatment. What are your thoughts on the most effective ethical way to conduct this testing in a treatment program? For example, who administers it? A consultant not involved in the treatment program?
Oh, that's a good question. I never thought about who. We use it in treatment. I think that it works really, really well in treatment. What better way to test what you've been learning in treatment and really working on than to actually go back in the lab and see if you're able to change that arousal. Yeah, regarding who administers it, I mean, I think that's an interesting question that you would think about your own ethics. If it is, I mean, I guess any forensic treatment can, be discoverable or can go to the court, but it is different in a treatment setting where you might use like a lower cut score because, this is just looking at your treatment progress theoretically for you and the treatment provider. But yeah, I don't know that I have thoughts about who administers it in a treatment setting. I think depending on how large your lab is and how many personnel you have, you might run into a situation where you only have, one tech or one person who interprets it. So I think kind of logistic issues as well.
Wonderful. Thank you. A couple of questions about PPG across the lifespan. So I'll ask one extreme and then one related question after that. Someone asked if you could tell us more about evidence and or use of PPG assessment amongst adolescents with problematic sexual behaviors or juveniles with sexual charges, specifically wondering about how developmental or hormonal differences and how they might impact the validity.
Yeah, that's a really good question. So we don't use penile plethysmography on individuals under the age of 18 in my lab. I'm personally not aware of labs that use it for juveniles, but there have been some studies, I think out of ASU, or University of Arizona, looking at PPG in juveniles and looking at different stimuli sets. So it's definitely been looked at in research, but as far as practice, that I'm not sure. But I will say from an ethical or assessment standpoint, I don't use it. I only use it with adults, so 18 and older.
And then someone asked if there are norms for changes in penile tumescence in males across the lifespan regard to controlled exposure to various stimuli.
Oh, great question. Off the top of my head, I'm not thinking of like a particular study to point to, but I mean, from the general sexuality literature, we know that you experience changes in your libido, changes in your ability to sustain, maintain an erection as you age. Medications can affect that. Health conditions can affect that. So yeah, I'm not sure. I'm thinking of a paper that like says what you would expect it to change, but the nice thing about the PPG is that when you use the Z-score, you're not looking at the millimeters of change, you're looking at the transformed scores from kind of their median arousal and comparing them within themselves. So you're not comparing them to other people, you're looking at the standardized scores and looking at like preference between different age groups or stimuli types.
A couple of people asked about assessing for paraphilic behavior among women. Could you discuss that briefly?
Yes. So there is photovaginal plethysmography, and that is used pretty widely in the general sexual arousal literature for women. So not looking at paraphilic sexual behaviors. They also use like a Doppler instrument to look at increased blood flow for women. At their sexual behaviors clinic, they made a stimuli set to potentially one day use with women who were charged with or convicted of sexual offenses. We did a really, really small pilot study using that stimuli set with non-offenders. So just, women in the community who volunteered. I mean, honestly, I'm still interpreting those results. I'm not sure what we found, but it's going to need a lot of research before we can say that like, okay, we're going to use this stimuli set with female offenders. So right now we don't do any kind of objective arousal assessment with women who have committed sexual offenses, but there is this instrument, and perhaps in the future that is something that can be used in that kind of setting.
And someone asked, as far as you know, does the PPG work as effectively for female to male transgender individuals?
That's a really great question. To my knowledge, I have not seen any literature on that. So that is something that definitely is an empirical question. So yeah, I have no idea, but those data are needed. So hopefully that is something that people are looking at future directions for research.
Certainly. Well, thank you so much, Emily, Dr. Gottfried, for answering all of these questions and sharing a lot of very helpful, informative information on the PPG and, of course, how it pertains to sexually violent predator aspects and risk assessment broadly. I could tell from the sheer number of questions that we got, this piqued a lot of interest and was very helpful to a lot of the audience. And always good to see you, of course. That wraps up this week's Law and Mental Health series. We hope to see you next week when Dr. Brianna Beaupre will be talking about gender-responsive correctional strategies. Until then, we hope you have a great rest of your week, and we hope to see you again soon. Take care.